Thanks very much. Appreciate it. Jonathan Wood, County Attorney.
I figure Frank is here because he wants to hear me say no report. But I'm not going to do that because Martha asked me to give an
Jonathan, I was really hoping for consistency.
Right. Me too, but it's not working out that way.
Got to come back next time, Frank.
So Martha has asked me to give a
to the microphone, John.
Sure. Because of some recent communications, the chair has asked me to give explanation of the New York State Division of Human Rights and how the complaint process works and how counties fit in, and in particular how our county fits in. So I actually took some notes, but I'll try to give a brief explanation. First of all, I should tell you a little bit about my background in it. You know, I've been in charge of that aspect of our Human Rights Department on 2 occasions, but I actually know a lot more about it from actually being a participant in the process, because we have, over the years, human rights claims against the county. We don't have a lot. If we get like one a year maybe, but I've been doing it for 25 years. So mostly what I know is I know from being part of the process. So I'm going to kind of explain from beginning to end how their process works, and then how counties fit in and how our county could fit in. So there's a state human rights law, and it's pretty comprehensive, and it prohibits discrimination based on a whole bunch of different areas, including race, creed, color, age, disability. Significantly in recent years, they've added sexual orientation and gender identity. They don't actually have a section gender identity, but they consider it part of sex. So current New York State human rights law protects gender identity as well as sexual orientation, and those are fairly new. So what happens if somebody wants to make a complaint, feels that they're discriminated against? The way it currently works is they fill out a detailed complaint form, which is online at the New York State Human Rights website. And there's actually more than one form. It depends on what sort of discrimination. For example, there's a different form for employment than if you're complaining about housing. And they're fairly detailed forms. It asks you, you know, about yourself, why you feel you're discriminated against, how you're treated differently from other people. And so you fill that out, and then you give that to the New York State Division of Human Rights office, which you can either deliver in person, send by mail, or send by email. After that, they have an intake process where one of their employees will basically speak to the person, and they have a sort of formal intake process, but they're trying to make sure, 1, that is a legitimate human rights claim, 2, that they have jurisdiction, and 3, that it's timely. But those things, so they have a set series of training on the people, and they go through it to do basically an intake process with people who want to file a complaint. If the complaint meets those requirements, they then send the complaint to the respondent, or which is more often than not an employer in most cases. Sometimes it's a housing person, but more often than not it's an employer. And then the employer or the respondent has an opportunity to answer, and after the answer, the complainant has an opportunity to do a rebuttal, in other words, to respond to the answer. That leads to an investigation stage of the process, in which they will assign an investigator, and that investigator will investigate in order to determine whether there is probable cause to believe that discrimination took place. How they've done that has actually changed over the years. There was a time where they would come to your offices, like they would come to the county and interview people here. Then there was a time where they did it by phone. There was a brief period of time when Eliot Spitzer was governor where they did no investigation at all. That I still can't understand or whatever, but that's what happened. But in recent years, what they've done is ask the people who they feel might have evidence relevant to come to their office, their local office. In our case, the local office is in Binghamton. So they will contact both the respondent as well as the claimant and say, we would like such and such people to come to our office in Binghamton at such and such a date, at such and such a time. And I can tell you it's not the most pleasant experience driving to Binghamton and sitting in an office and then driving back. And usually they may want a group of people. They may say, we want to talk to these 4 or 5 people. And it's for both sides. It's not just for the respondent. It's for the for the complainant as well. And what will generally happen is that the person who's doing the investigation is usually pretty well prepared. They have a series of questions that they want to ask each side, both the claimant and the respondent. And maybe, like, to give an example, I'll give, like, for example, the last case that we had, or part of it. So we had a woman who was claiming that she was discriminated against on the basis of her sex because she was given a more discipline for being late to work than a similarly situated male employee. And so she presents evidence on that, including her statements and whatever written. And then it becomes incumbent on the employer, if we wish to avoid a finding that that there was probable cause, to come forward with a legitimate non-discriminatory reason. So in this case, or that is simply not true. So in this case, for example, the situation was, and their finding is that the woman had been tardy or late 11 times, and the supposedly similar situated male had been late only 2 times, and that was a legitimate non-discriminatory reason, so they found no probable cause. And fortunately, in the years I've done it, we've either always had no probable cause, or a few that have gone to hearing, we haven't lost one, at least to date. But in the event they did find so they found no probable cause, and in the event they find no probable cause, that really ends the complaint there. In the event they find probable cause, that means that the claimant is entitled to a hearing. The hearing part is important because they do several things. One, they provide an attorney for the claimant. They need to make a record. So they have a stenographer, a way of making a record, to make a stenographic transcript, and they provide an administrative law judge. So basically, if you've ever done a case where you have to provide 2 attorneys and a stenographer transcript, it's a fairly expensive process. And the reason the state has, unlike any municipality or county, because they do this for 56 counties, they have a staff of attorneys, and they have a staff of administrative law judges, and they have a staff of people who do stenographic work, so that they can basically provide this service, which realistically, 1 or 2 counties couldn't provide. But they are able to provide this service, including a lawyer and ALJ who is an attorney who's trained, as well as stenographic services. So then they'll have a hearing in the event they find probable cause, and it'll be pretty much a hearing like you would expect. There's testimony, there's documentation, and then they'll make a determination, which is really a recommendation, which is basically whether the person established their case or whether there is the person did not establish their case. In the event that they believe the claimant established the case, and again, the ALJ makes a recommendation to the commissioner, but they have the power to give orders to an employer, for example, to stop doing something or to do something. They have the power to give damages to the claimant for whatever damages, and they also have the power to give civil penalties, which, depending on different circumstances, but can be significant, either $50,000 or up to $100,000 in some certain circumstances. Fortunately, we've never been in that situation on the wrong side of that, but they have significant powers to present, to penalize those who they determine violated somebody's human rights. They also have the power to both legally and financially to enforce whatever orders they have. They have an enforcement division which can go to court, which can give orders to people, you know, you must comply, you must hire this person, you must pay this person the damages, etc. So that's pretty much how the state system works. How counties fit in, I'll try. First of all, there are, I know 2 and there may be 3 counties that do probable cause determinations. And they do that pursuant to a memorandum of understanding with the state. I know Nassau and Suffolk have that. I think there's a city, maybe Yonkers, but it's only some large downstate municipalities. And what they do is that they do a probable cause recommendation, which means they do the initial intake as well as the initial investigation and make a recommendation as to probable cause. This has advantages and disadvantages. The major disadvantage is, as we know from when we did it, and maybe it's different now, but you pay for it. The state doesn't give you any money for it, so it costs money. In my mind, having done these many, the major advantage of it is that it's local. You don't have to get everybody up and go to Binghamton or whatever, and that's a convenience for both sides. So there's an advantage to it, but at a cost. So the question is, so why are there so few counties that do that? And the reason is that the state, at this position of the state, and it's been this position of the state for many years now, is that they believe that the amount of training and oversight they have to put in to have municipalities or counties do that is significant, and it only makes sense if the counties are large enough and have enough complaints where it makes sense to do that. So, for example, Nassau and Suffolk, they have a population of over 1 million people. They have a lot of claims. The state feels that it makes sense for them to train people there and supervise them, but for smaller counties like us, it doesn't make sense to them to do that. Now, as you know, in the past, I think 2008 was the last time we had an agreement. They had a different position. They were willing to work with smaller counties, but that's really not the position now, and it's not realistic that it's going to change in the immediate future. So now I kind of want to talk about what Tompkins County is and some of it does and some of the issues that have arisen.
Well, Jonathan, this is really, really interesting, and I've never heard all this before. So are there any questions first on what you've said so far? Anne and then Deborah.
Just make one addition that I learned, which was very interesting, is that the state has a very complicated database that they use. And so if they have an MOU, they give those counties access to that database, and that's actually part of the complication too that they look for in relationships. And that was something that they shared with me that I don't know if you dug into a bit.
Yeah, I mean, they do have a database which helps keep track of various, you know, what types of claims, what the rate is, that sort of thing. I'm not sure how that, you know, it's helpful for them to know what kind of claims they get, et cetera.
That was like client information.
Okay. Deborah, Leslie, and then Henry.
Could you please remind me what happened with the MOU we had once upon a time?
Yeah, it simply lapsed. I mean, the MOUs were for 1 year period.
Microphone, please.
Yeah, oh, sorry. Yeah, it basically lapsed. The MOUs were for 1 year periods. And the state, I would say, I mean, they didn't exactly say at the time we don't want to renew. That what they said is we renew only under conditions which really didn't work. But I think they really just didn't want to renew. So basically it lapsed as the other smaller counties, you know, I mean, there weren't a huge number, but they let them lapse essentially.
They let them announce, the state did.
Well, yeah, I mean, the state was the one I think really wasn't interested in continuing.
Leslie and then Henry.
Jonathan, for the counties that have memos, you said the state, they can do up to probable cause determination. And then what?
Okay, so if they determine that there's no probable cause or probable cause, that is a recommendation, it then goes to the state.
Then it
So
goes to the state, and the state picks it up from there.
So assuming they find that there's no probable cause and that recommendation is adopted, that ends the case just like.
Right.
If they recommend that there is probable cause and that recommendation is adopted, then it goes to the state system with the hearing, et cetera, where they'll be assigned an attorney if they need one, where there'll be an ALJ assigned, administrative law judge, as well as, a method of keeping a record. So then it just basically goes into the state system like any case. So basically, the county is acting like an investigator for the state.
Okay. And once it goes, let's say there's a probable cause determination and the case gets sent to the state or filed with the state then picks up the costs from there for the administrative law judge and everything else going forward.
Yes, exactly.
Thank you.
Henry.
Jonathan, for the initial part of filling out the form and intake process, that all occurs where? Where does that?
So the process of doing the probable cause determination, if that's what you're talking, so is that what you mean?
The intake?
The intake process that you talked about, where is that?
That I'm honestly not sure because it may vary from case to case. I mean, and it could also depend on the, for example, which office the State Division of Human Rights. I assume that most cases, if not all, from here are done in Binghamton. Right. Now, whether they may on some occasions just do it on the phone with a person or whether they require they would come in, I'm not sure necessarily. I think if the person couldn't come in, they'd probably let them do it on the phone. But I assume most cases from here, I'm obviously not involved in that part. They would do it in the Binghamton office from here, depending on where the claimant is from.
Okay.
Anna?
Did you discuss when you spoke with the state about their practice now about building MOU relationships again with counties? My last conversation with her, she said that they were open to it as long as we could show that the numbers of cases, potential cases we had, were high enough to make the training and all of that worth it. And I was curious if you'd had any further conversation.
Not specifically, but our numbers definitely wouldn't even be close.
Right, which was...
Yeah, I mean, the numbers, I think, can pretty much mirror the population. And, we don't have a huge population. We don't have a huge number of claims.
So the cost effectiveness of doing it.
Yeah, I don't think it would be close in their mind.
Thank you. So, go on. The next part. This is great.
So what happens now in Tompkins County? What do we currently do? So what we currently do when someone comes into our office with a complaint, we have an intake form, which is our own intake form, different from the state. And we have an intake process where one of our persons will interview the person, gather documentation, review what we feel is the relevant law, and help that person draft a complaint, which would then be sent to the state. So an issue which has arisen, which you probably saw in a recent email, is that the state has indicated that they would prefer that we not do that. Now, what they want us to do is just direct the person to their website, to their process, and to follow their process. Now, understand this. The state understands this too. They have no power to direct us to do anything, and we can do whatever we feel is the right thing. So, obviously, up till this point, we felt that that's the right thing, that that's beneficial to the process and to the claimant. The state issue with that is a couple things. One is they do their own intake, and they feel like, so you have two intakes, like one intake at the county and then a separate intake at the state. So it's two intakes. Second, they feel that some people that come through to the state after going to the county are confused about the process. They feel, well, didn't I already do this kind of thing? And it creates some level of confusion for them. And third, that because the training of the people is somewhat different, that the result, they believe, might be somewhat different. And for example, they may look at a complaint that we do and say, well, in our intake process, this or that claim might have been weeded out. So they prefer that we not do that. You know, obviously we wouldn't do that or been doing that if we didn't feel it was helpful to the process. And to be honest, I haven't discussed it with the staff. It's a new issue to me. And I have to kind of think about it, about what is best. But that's the issue that has been raised, and I think you got an email about it, and I'm just trying to clarify what the issue is. Haven't made any decisions or anything on it, but that's what the state has expressed as their concern, and that's what we do. So that's the other thing. I do want to say a little bit about our county local law, because you've seen some references to that. So we have a county sexual or non-discrimination law. I think in 1991 we first adopted it, and it covered just sexual orientation. And the reason why it was done is because the state law didn't cover sexual orientation at that time. Now it does. I wasn't here at that time, so that predates me. Then in 2004, we extended our law to cover gender identity and expression. I was here at that time. I was active in that. And of course, we did that because the state law didn't cover gender identity and expression at that time. Now it does. Our law is a little different than the state law. In fact, it's kind of significantly different. What our law really does is it declares those things are illegal, and it allows for us to do an investigation, probable cause, a fact-finding, and conciliation. But what it really does, because we don't have any penalties and we don't have a process to provide attorneys or an ALJ or anything like that, administrative law judge, it basically provides claimants with an opportunity to bring an action in court because it now has a law which says you can't do that. You can't discriminate on those things. It's not a comprehensive process like the state has, but of course the state didn't cover those things at the time. So, I mean, our theory was that this would prevent people from being discriminated on those things and would give them a cause of action in court for discrimination where they could proceed and get damages. And it also provide a process where we can do an investigation and we can make findings and try to conciliate. So that's what our law is and does. Almost anything which falls under our law now falls into the state law, which wasn't the case when they were adopted. So that's kind of my explanation. I'd be happy to answer any questions. I hope that's helpful in understanding it.
Yeah. Deborah?
So I want to be sure I understand this. The state law is caught up with our law in terms of reaching allegations of discrimination on the basis of sexual identity and gender. And
yes. Now, they specifically added language for sexual orientation, and the thing on sexual identity stuff is basically they've interpreted their law, which prohibited discrimination based on sex, as covering those things.
all right. So meanwhile, the state law is now pretty much as broad as our law, with the exception of creating this independent cause of action that someone can bring, I assume, at their own expense.
Well, the state law does that too.
Okay.
So you have that choice. I think most people choose to use the state system because it's better than just bringing a lawsuit.
So we have these two laws that basically cover the same thing. And then we have the state that says they no longer want us to do intake for their law.
Right. Well, yeah, pretty much, yes.
So I guess my question, which is probably not going to be terribly popular, is why do we have an Office of Human Rights in Tompkins County?
Well, can I say one thing to begin with is complaints is just one aspect of the Department of Human Rights.
Okay, so
we focus a lot on that thing, but that's not the only thing the Department of Human Rights can do or a commission does.
What else do they do?
Well, I mean, community education and programs. I mean, you know, that's one thing we're sort of exploring is more things they can do, but community education, teaching people about human rights, you know, educational programs and that sort of thing. But for many years when we were doing probable cause determinations, the focus of the department was on that, and we had actually 2 investigators, and the head of the department spent significant time on that.
And then Henry?
I think in addition to what he's saying, actually, historically, one of the most useful things that I think OHR did was mediation, which is not what he's speaking about, and I think that they did it very effectively. So that's pretty big as a part of a conversation, then education, then outreach, and handling everything with respect to OHR within, you know, they could do within the within the government and within the community. So that would be our outreach arm, but mediation is a big piece that we did previously that was important.
Do we do it anymore?
It has not been done in the last couple of years. That is not something, it was a focus on getting the local law and a focus on some of those conversations of the MOU, but the real focus of the office has been whether or not they would, trying to get their energy to get a local law that would replicate what the state has or duplicate what the state has.
Yeah. The term is conciliation that they use in the human rights context.
Conciliation.
Yeah.
They still have the authority to do that.
Conciliation.
Right, and we can do conciliation anyway on the state claims, whatever, and have been able to actually, since I've been there, been able to do that in 1 or 2 cases, but it hasn't really been an emphasis of the office.
Henry?
So, under all county law, they have a right to go to court and sue and collect damages?
Interestingly, the law doesn't specifically say damages, but if you violate the law and you cause me damage, then I would be entitled to sue for damages, yes.
Do you know how many cases people are advised to go through all county system, or are they advised to go use the state system?
Well, I don't know anybody that has brought an action under our county law, certainly in recent years, and it would seem a better approach for most people, I think, to use the state system because, you know, they provided an attorney, that there's, you know, they have all the powers of a, you know, basically of a court. So, I mean, it's probably a better avenue. I mean, I don't advise people on making claims, but it seems that that's probably a better avenue for a person who feels they're been discriminated against.
They have to slap down to Binghamton.
Right.
So if they go and sue here under our law, they have to pay all the costs.
Right. There's no, you know, I mean, obviously they may be able to find an attorney who may be wanting to represent them, or, but there is no provision for paying. We don't provide an attorney. We don't provide an administrative law judge. So it's up to them, basically.
Okay, let's see, Leslin and Amanda. Not Amanda, yes, Leslin. Okay.
So, Deborah, that's an interesting question. And I would venture to say that there's been a lot that this office has been responsible for within the community, and there's a level of, was a level of trust and comfort in the community to know that things didn't just get lost in a black hole when it got sent to Albany or Binghamton or New York City. Because at one point, all the state, I think, sexual harassment cases were going to New York City. At any rate, the education component was huge, and really doing a lot of work to help employers and landlords and whomever else avoid getting themselves into pickle with understanding what the laws are. I think there's still, when the office was restructured, I think there's a big part of it as well. So that has been good. And even the education with the children and then the schools in understanding universal human rights. So there was a lot of that. That the office, so there's a significant benefit that the office has played for people in the community. And if not for anything, just knowing that there's a local place you can go to that will help you navigate the state system. That has been very important. Jonathan, I have a question for you. If we decided, or if we said, yes, we're going to have a law that matches what the state has, somehow it doesn't seem like it makes sense since there's already an existing state law. But if we did, as we had been exploring locally, then we are then taking on the responsibility of mirroring what the state did, like providing the attorney and all of those things, and adjudicating, I don't know how to say it better,
right.
The cases and meting out the penalty.
Right. I mean, you have the issue of the person being represented by counsel. You have the issue of making a record, a stenographic record. You have the issue of a qualified administrative law judge making a decision, and then you have the issue of enforcing.
So if we chose to have our own local law that mirrors the state law, or more, because Tompkins County cutting edge before gender identity made it to the state level, we were doing it, or discrimination. If we chose to do that, then all those things you mentioned then becomes our financial responsibility.
Right.
And is there any part of it that we could say, well, no, you're on your own, find your own attorney?
Well, I mean, what we could do and what others is basically say that so you get to the point where there's probable cause that the county or the county could represent you in court or something like that rather than provide, I mean, you know, still obviously an expense or stuff, but less so than providing you with an attorney and an ALJ and a transcript and all that kind of thing. So there are some like human rights laws, local laws, for example, which could provide that the municipality would then provide representation or something like that.
I have a lot more questions, but it's late.
Okay, Anna and then Mike Sigler.
Adding to a question that was inspired by Leslie's question, and then this might be half-baked, outside-the-box idea, but would it be possible to create a local law that got us to probable cause and not all the way through, because that cost difference? I mean, I know that's basically mirroring an MOU rather than the full state law.
Yeah, no, the answer is no, because the state wants to do its own.
I understand. That's why I was trying to figure out if, you know.
Yeah, I mean, it wouldn't count for anything. I mean, you can do it, but then you'd be
But the state would just repeat it.
Right, exactly.
So you're putting the parties through two processes. Right. Okay.
Which is what I thought. I just wanted to work it through.
Mike Sigler?
So you're saying that the county would pay for this person's attorney? So we would
Well,
pay for one representation against another citizen who's not been convicted of anything?
Yeah, I'm not recommending it. I mean, that's part of the issue in that, you know, so when you're doing probable cause determinations, for example, you really need to be objective because there's two sides, and both of which are Tompkins County residents or businesses. So it does present an issue, you know, obviously it's only if there's that determination, but yeah, that would then put you against another county entity. So
I don't like
I'm
that
not
at all.
recommending that. I'm just saying that, you know, I mean, when the state enforces one of their orders, they're in essence enforcing an order against somebody who's in their state, right?
Goes through a DA.
But I'm not, but it's them, it's not us.
I would think it would go through the Attorney General, and there would be somebody kind of signing off on that.
Right. The point, I guess the point is, and Leslie's question gets to, is after you get to the point of saying there's probable cause, you really need to have some adjudicatory process which is fair to both sides and has professional determination. And that's what the state does, and that's what's really difficult for any small municipality to do.
Okay, I'm pretty sure this won't be the last time we talk about it, but this has really been very helpful, Jonathan, and I thank you for taking the time, and I really appreciate it. Anything else? I'll say.